My lady, you have not been supplied with any authority from the Court of Appeal to support the state's connotations. You have not been supplied with any authority from the Supreme Court under the principle of stare decisis. This court is bound by the pronouncements of the Court of Appeal. My lady, the defense has provided this court with the decision Criminal Appeal number 113 of 2018 in the Court of Appeal, Nairobi, Michael Juma Oyamo and Albert Ojwang and the Republic. The judges in that decision is the President of the Court of Appeal, Justice Musinga, Justice Wasame, and the late Professor Judge Odek. What are the requirements for the state to succeed to deny, for the court to deny bail? My lady, this is a case that you have dealt with severally. I will only deal with what the court said. In page, my lady, in page 3, on the determination, paragraph 23, the court says, and I quote it verbatim, the first compelling reasons would denote reasons that are forceful and convincing as to make the court feel very strongly that the accused should not be released on bond. Bail should not, therefore, be denied on flimsy grounds, but on real and cogent grounds that meet the high standard set by the Constitution. My lady, that is this Court of Appeal. Number 2, my lady, in paragraph 25, the court moved on to say, subsection 2 therefore stipulates that a person who is arrested or charged with an offense shall be granted bail unless the court is satisfied that the person, that is the first accused person, the fifth accused person, and the sixth accused person, has previously been granted bail and has failed to surrender to custody. But lady, none of the three or the others has been granted bail and they have failed to surrender. Free, my lady, the judges are saying, and that if released on bail, whether or not subject to conditions, it is likely that he would fail to surrender to custody. Therefore, should be kept custody for his own protection. Lord, this is the Court of Appeal pronouncing itself. Paragraph 26. The court says the court has had occasion to pronounce itself on all these constitutional and statutory principles regarding bail in the case of Republic versus Nuseiba Mohammed Haji Osman. Nuseiba Mohammed Haji Osman. EKLR 2018. What does the court in that authority say? Denial of a constitutional right is not a matter to be treated lightly. And therefore, any claim made against an accused person aimed at curtailing the constitutional right to liberty must not be made on speculation or upon change. My lady, all that has been brought before you from the affidavit of IPOA to the probation prebail report are speculative, purely speculative. What do the judges want? Paragraph 27, turning to the impugned ruling, the learned judge found that there were compelling reasons for denying bail to the applicant. She stated the reasons as being that they may send fear, anxiety to potential witnesses, and therefore lead to intimidation of which may adversely affect the case. That is the High Court that denied bail. Similar reasons that the state is telling you that if you release these people, they will send fear, anxiety to potential witness, and therefore lead to intimidation of which may adversely affect the case. That was the position in the High Court. And somebody was denied bail. What did the judges prescribe? The judges put it in paragraph 32 that in the investigating officer's affidavit, the prosecution did not demonstrate how the appellants were likely to interfere with the prosecution witness. Similar to this one, they have not demonstrated. Mr. Mwangi merely stated that the first appellant, being a personal assistant to the governor, wields influence and power of the behest of the governor. The same narrative that the first accused person is just a police officer and an OCS. It goes to further, my lady, to say, and therefore there is real risk, and they've released on bail.
Is he resubmitting again?
I'm reading the law.
Again?
I'm reading the law.
I would like your guidance.
Although he's making reference to your submissions, then he's now supporting with the law. I think he's okay.
Purely the law.
He's referring to what you submitted and controverting with the law.
I told my good friend to appeal to the Court of Appeal. They have never appealed. This decision could have gone to the Supreme Court. It is now the law. Thank you very much. My lady, let me proceed. And it says, and therefore there is real risk that if he released on bail, he may reconnect with other persons who may have committed the offense jointly with him and put prosecution witnesses at risk. He also contended that some of the key witnesses come from the same area as the appellant, and thus there existed chances of interference with the witness. He further contended that the victim's family was under threats and intimidation, and they believed that the three accused persons were behind those threats and intimidation. The judges in paragraph 34. The judges in paragraph 34 say,
you have to summarize.
I've finished. That is the whole of it.
You know, you are reading, I've tried to catch up with you.
No, you have
so,
it. I'll have it, the authority,
okay.
To save on time.
So
Paragraph 34.
Yeah.
The judges now responded. We find this explanation insufficient. Paragraph 106 of the Criminal Procedure Bench Book states as follows. 106. The fact that the accused has been supplied with witness statements does not warrant the denial of bail, unless there is evidence of a real likelihood of the accused interfering with witnesses. They quoted R versus Peter Mawia in the High Court at Machakos criminal case, number 48 of 2015, said bail should not therefore be denied on weak grounds, but on real and cogent grounds that meet the highest standards set in the Constitution. Allegations of witness interference, my lady, that is a killer punch for the state. Allegations for witness interference must be supported by evidence. By evidence, none of that has been supported, has been provided to you. None. That is the Court of Appeal say. They were to show real, and that is why we relied on Great Sagari. What did the judges say? They allowed the appeal and ordered that the appellant therein be and hereby granted bail on the following terms. Each appellant may be released upon depositing into court cash bail of Kenya shillings 1 million.
No, that's not part of the law.
So, in summary, we have nothing more to add.
Thank you.
I hand over this matter, and the state can still apply to the Supreme Court to challenge it.
Right.
But for now,
Yes.
that is the law. Thank you, my lady.
I hope you've covered this.
Yes, my lady, mine will only be in bullet form.
Purely on points of law. What
Purely
they
on
say
in
that
fact,
you are, yes.
Yes, I'll
You
just
are
stick myself,
yes.
I'll just stick to bullet form.
Okay.
So one thing, you've been told about public interest and public confidence. My lady, I'll refer this court to the submissions I made on the 24th of June. And also, in the case that we have provided, that is the one that was decided by Philomena Mwilo, the Lady Justice Philomena Mwilo, that is Republic versus Musili. At paragraph 12, 13, and 14, my lady. Secondly, you've been told that there is a need that this court must instill public confidence. And we ask ourselves, my lady, what is public confidence? Is public confidence saying that all police officers should not be granted bail? Or is public confidence upholding the provisions of the Constitution that all persons are entitled to bail without discrimination? So I will let the court choose which exactly, when we talk about public confidence, what is public confidence? My lady, you've been referred to the case of Republic versus Frederick Oleliman. And my lady, I must say with a lot of humility and respect for my colleagues, that there's a danger in reading decisions while choosing to omit paragraphs. What we term academically as selective reading. My lady, in the case of Republic versus Frederick Oleliman, the Honorable Judge states gives three substantial grounds that must be demonstrated by the prosecution. Yes?
Which paragraph?
My lady, it was referenced in the case of Republic versus Ayeko, the one that I provided before court, at paragraph 18. The Honorable Lady Justice Rhoda Ruto replicates the reasoning in Frederick Oleliman. And one is whether the accused person will fail to turn up at his trial or to surrender to custody. That is one. Two, that the accused may commit further offenses. And lastly, he or she will obstruct the course of justice. But again, immediately after giving those primary or those three grounds, the court in that same matter goes on to state that the primary consideration in deciding whether or not to grant bail to an accused person is whether the accused is likely to attend trial. In making this consideration, the court must consider...
I'm sorry to interrupt. Is that in the Leliman case or is it in the other case?
It is in the Leliman case.
Paragraph what?
Just read the one that I separated.
Paragraph what?
Paragraph 18 of Republic versus Ayepo.
So it is not the Leliman case?
No, just read.
So it is not the
It is not
Leliman
difficult.
case?
It is not difficult.
So it is not the Leliman case?
It is actually is. Not unless you're saying...
Paragraph what?
Not unless you're saying
Paragraph?
Justice Ruto was actually replicating her own things.
It's not.
No,
It's
my
not
lady,
the one.
my lady, she makes reference and goes on to replicate.
So she simply
Yes.
asked which paragraph,
Paragraph
of the Leliman,
18.
of the Leliman case,
Yes.
or you are saying
Yona,
the judge
Melody,
is
I've
citing.
Yona, with
I've
much
been told I
respect,
did
and Yona, I
selective
take so much
reading.
exception.
So that's why I want to know in the Leliman matter, which paragraph is he referring to? Because
My
he's
lady
talking
will
about
also
the
realize
Leliman
that
matter.
I'm actually responding to the submissions by my senior and my colleague. And they actually cited the case of Frederick Oleleman. Unfortunately, they are not in the habit of supplying they are not in the habit of supplying authorities.
Where is the
to us.
selective reading?
Therefore, I mean, it
Where
is
is
there.
it selective?
You know,
Paragraph
anyway, I
what
choose
in the
to proceed.
Leliman
Let
matter?
me just choose to proceed.
Melody,
opposed to-
there's a problem there.
Okay, let's see. We can all read, the court will be able to read, but you have not given the paragraph. So you are citing the decision of Justice Ruto, and you are
Justice
saying
Ruto.
Justice Ruto cited Leliman.
Replicated
Leliman.
Yes.
We will find it.
Actually, word for word.
The law is like the Bible. We will just find the
Thank you, my lady.
scriptures
So
if you
I do
want
not now understand why there's
If
so much.
it is not there, then the court will not find it, and I will make reference to that.
Thank you. And perhaps next time, my lady, they can also be advised to be sharing authorities.
Okay. Proceed though.
Yes?
Proceed.
Yes.
Actually, the court departed from its modus operandi. I would have adjourned this matter to give you a date to come and make submissions. Probably that explains why they do not have authorities to support. But because I saw all of you here, I decided to proceed. So that is forgivable.
Thank you, my lady.
Because the
We
matter was not
appreciate.
coming up for hearing today, it was coming up for directions on the previous report. But I
Yes, my
decided
lady,
to
we appreciate the
proceed.
industriousness of this.
Okay, proceed. I missed your third point, whether the appellant or accused will attend trial, whether he will commit other offences, and the next point was?
Yes, and the primary consideration in deciding whether or not to grant bail to an accused person is whether the accused is likely to attend trial.
Yes.
My lady, that sorts that issue of Frederick Oleleman. The third issue was the fact that, again, these are police officers, and I'd like to direct this court to paragraph 12 of Republic versus Musili Durok Kitome.
Republic versus?
Musili Durok Kitome,
Yes.
paragraph 12. And my lady, if you allow me to read or not, it's at your discretion, but I'm trying to save on time. But the gist of that paragraph is that the court is saying that it is not aware of any provision of the law that states that policemen per se is a security risk. Again, it goes on to buttress that there must be equality before the eyes of the law. And on that ground, the prosecutor, or rather the prosecution, was found to have failed in that ground. My lady, next to, going on to my next point, this was the submission by the victim's advocate. where he referred this court to my own authority, Republic versus Obambo, and again selectively chose to read paragraph 14(2)(b) of that decision. And he replicated and said that a person who is arrested or charged with any offense shall be granted bail unless the court is satisfied that the person should be kept in custody for his own protection. That is what he said. But again, my lady, we already established that in fact, in this time and age, Justice Mwilu calls that medieval thinking. You cannot tell an accused person that the only place is safe is a police cell or a prisoner remand, my lady. The Constitution binds state organs and state actors by the Articles 29C and 238 to secure the safety of all Kenyans.
Articles?
29C and 238. Therefore, my lady, I would ask this court to shun that medieval thinking, as it was so called at paragraph 13 in the Republic versus Musili Durok case. Finally, in the employment of restrictive measures, where it was argued that he is still a police officer, my lady, I refer this court to the interdiction which was applied to the court, where the suspension was anchored on section 149(9) of legal notice number 90 of the National Police Service Commission Act.
Anchored on section?
Section 14(9) of legal notice 90. And that particular section, my lady, states that, notwithstanding paragraph 8, during an officer's interdiction or suspension, as the case may be, the officer may be required to proceed to his permanent residence and to report to the local police station or post as prescribed in the service standing orders. In fact, verily, my lady, the first accused was directed as a direct order to leave Nairobi and go to Eldoret. And as it has been argued that he's still a serviceman, indeed he is bound by legal notice not legal notice, but the National Police Service Act number 11 of 2014, where he is still subject to discipline and penalties if he disobeys this direct order. And my lady, we therefore submit that having lost his police powers by virtue of that interdiction and being expelled from Nairobi to Eldoret, and as you have been told that this crime actually happened in Central Police Station, which is Nairobi. So therefore we are confident that the first accused person is not going to be anywhere near the scene of crime. That's all, my lady. Thank you.